Will the parties please rise and make their appearances, starting with the government? Miss Poskeren, good morning, Your Honor. Rushmi Poskeren and Peter Davis for the government. The court, good morning, Miss Kirshner. Good morning, Your Honor. Isabel Kirshner for Ms. Respass. The court, good morning, Miss Kirshner. Miss Kirshner, have you received a copy of the pre-sentence report and had an opportunity to review it with your client? Miss Kirshner, yes. The court, do you have any objections or corrections to be made to the report itself at this time? Miss Kirshner, no, Your Honor. The court, all right, then let me first turn to the government. Does the government wish to be heard further on sentence? Miss Poskeren, just very briefly, Your Honor. The government in this case recommends a custodial for this defendant below the guidelines range. We're happy to answer any questions from the court should the court have any questions for the government, but otherwise we'll rest with that recommendation. The court, all right. Ms. Kirshner, do you want to be heard on sentence? Miss Kirshner, yes, Your Honor. Very briefly, Your Honor, as you know, this is a case that's been pending for a long time, for 4 years, and we're finally here. And this is a very pivotal moment for who I'm going to call Yonette Davis, because that's actually her name, in her life. Let me begin my remarks by pointing out in the courtroom today there are a number of family, friends, and even co-workers here to show their support for Star, which is how she's known to her friends and family. And in speaking to them, they're here not only today but going forward. These people are committed to making sure that she remains a productive and law-abiding member of society in the future. Both the PSR and my submission lay out a narrative about Star's family that is tragic and unfortunately too common, and it's a narrative which results in a child's inevitable repeated conflicts with the law. And in this case that child grew up to be an adult with repeated conflicts with the law as well, and the PSR details her criminal history and conduct, none of which she is proud of and none of which she can change. That's all in the past, but what she can do and what she has done is change herself, and be a very different person in the future. That's one thing over which she has control. Now I always tease Star about our long-term relationship. I met her in late February of 2020, days before the birth of her son, and in the following months and years, we spent countless hours speaking, not only about this case but about her life. And what I have witnessed is the growth and maturation of a young woman who, frankly, was rudderless, was at home during lockdown with a newborn for months, and someone who thereafter became a very strong, reliable, mature, responsible mother, whose only goal is doing what's best for her child. She is laser-focused on providing him with a stable home and a loving environment, something she obviously did not enjoy as a child, but something she instinctively knows is the most important gift a parent can provide to a child: unconditional love and support. As you know, within weeks of lockdown, Star lost both of her parents to COVID in April of 2020. She was obviously devastated, but what I saw in this tragedy was that she really steeled her resolve. She understood that it was on her to do, and over the last 4 years, she's done what we want everyone who comes into this system, into the criminal justice system, to do. She has matured, she has worked nonstop, she's become a productive and a contributing member of her community, all without the emotional, financial, and societal costs of incarceration. That's all in the past, but what she can do and what she has done is change herself, and be a very different person in the future. That's one thing over which she has control. 4 years where she was employed, fully compliant, with all the conditions of her release. 4 years of intense scrutiny and pressure by social media. 4 years where she paid her bills and supported her child. So what I view this case as, it comes down to faith and investment, and I don't mean religious faith, I mean faith and belief that people can be redeemed, faith in a young woman who has already demonstrated that she can and did change, faith that the love for her child and sense of gratification of giving back to her community will keep her out of the system in the future. And it's also about investment. It's an investment in her future and her child's future, who will necessarily be profoundly impacted by separation from his mother should Your Honor impose a period of incarceration, and we all know that the results of that are never good, so it's really an investment in all of our futures by doing all we can to assure that she remains on the positive path that's taken, and I plead with this court to let her continue on that path that's taken, and I plead with this court to let her continue on that path. Thank you, the court. Ms. Davis, is there anything you want to say before I impose sentence? The defendant. Yes, there is, Your Honor. Good morning, Your Honor. I don't know what I can say to convince you that I take full responsibility for the crimes that I've committed and have pleaded guilty to. I hope that my actions over the last 4 years speak louder than the life that I lived before my arrest on these charges. I know that I acted in a way that caused harm to others and are not the way anyone should act. I apologize to those who I hurt and to the court for my actions. I wanted to express to you that I'm no longer the person that I was before my arrest in 2020. Not only did having a baby change me but also losing both my parents back to back. It opened my eyes to knowing that I have no safety net and it's time to be a mature adult. Being a mom and knowing that I'm responsible for another human is the most scariest thing I ever had to do in my life, but I wouldn't change it. During the past 4 years, from dealing with the loss of my parents, house arrest, battling depression, and raising my son on my own, it has built me to be a better and stronger-minded person, and it also made me value life, all life. My life isn't the same as it was 4 years ago. I now have a human who needs me and relies on me, and it's really important for me to set a great example for my son and others. I do a lot of community work with young adults, and I try to push them into the right direction. For the past 4 years, I've worked with the community to help the less fortunate, done toy drives, food drives, and I also worked with youth basketball. Since August, I work at a homeless shelter, working 140 hours every 2 weeks just to support my son. I'm doing everything I can not only to prove to you that I've changed but also to prove to myself. I know I have been given plenty of chances in the past, and I know I failed. I'm asking you that you give me one more chance to prove that I've changed. and I promise I won't be back before you or any other judge. Thank you." The court: "All right, I've reviewed the pre-sentence report and I accept the factual recitations in the pre-sentence report and the guideline range is calculated as a total offense, level 27, criminal history category 3. I've considered the written submissions and the arguments made today on the defendant's behalf. I've considered all the factors in 18 U.S.C. 3553 relevant to sentence. In this case, I believe that given her post-arrest conduct, it warrants a sentence below the guideline range, and I intend to impose a sentence below the guideline range, but I think it would be unreasonable, given her criminal history and given the fact that she was a leader in a violent gang and was responsible for significant violence that took place, that it would be 1. Unwarranted sentencing disparity for her not to do some time in this case, and 2. It doesn't erase the violent conduct which is represented not just by these offenses in these two indictments but that are represented by her criminal history. So considering all of those factors, I believe that a reasonable sentence in this case, and the sentence I will impose, will be a year and a day, and I will impose that sentence on each of the separate indictments, to run concurrently with each other. I'm going to also impose a period of 3 years supervised release on each indictment. The mandatory conditions of supervised release are imposed, or local crime. The defendant shall not commit another federal, state. The defendant must not unlawfully possess a controlled substance. The defendant must refrain from any unlawful use of a controlled substance, and must submit to at least one drug test within 15 days of release from imprisonment and at least 2 periodic drug tests thereafter, as determined by the court, or by the probation department. The defendant shall also cooperate in the collection of any DNA as directed by the probation officer. The standard conditions of supervision 1 through 12 as recommended by the pre-sentence report are also imposed, with the special condition that the defendant shall submit her person, residence, any vehicle or property or papers or electronic devices to a search on the basis that the probation officer has reasonable suspicion that a violation of conditions of supervision have been found or there's unlawful conduct. Defendant must also participate in an outpatient mental health treatment program as approved by the probation office. The defendant shall not associate or interact in any way, including through social media websites, with any gang members, associates, particularly members and associates of any Bloods gang, in particular the 59 Brims, or frequent neighborhoods known to be controlled by the Bloods gang or any of its subsets. I've considered also that this is a reasonable sentence, although it is a sentence significantly less than the other defendants in this case have served, but I've taken into consideration the submissions to the court and the family circumstances of the young child that she is now the mother of, but given all of the circumstances, that can't erase the damage that's been done by her criminal conduct over an extended period of time and the violence that she was personally responsible for. So I believe that this is the appropriate and reasonable sentence to impose in this case. Ms. Davis, you have the right to appeal this conviction and sentence to the extent that you've not waived such right at the time of your plea. If you wish to appeal any portion of this conviction and sentence, you should discuss it immediately with your attorney. In order to preserve your right to appeal, a notice of appeal must be filed on your behalf within 14 days of entry of today's judgment. I will allow her to surrender. Ms. Kirshner, Your Honor, may we have July the LST? The Court, you want July 1st? Ms. Kirshner, yes. The Court, so she should surrender to the institution designated by the Bureau of Prisons or to the United States Marshal no later than 2 p.m. on July 1st. Ms. Kirshner, and one last thing, Your Honor, if you could recommend to the Bureau of Prisons that she be designated to Danbury, that's the closest women's facility to New York. I believe the Court. I will make that recommendation, obviously, subject to the availability of space and security. Determinations of the Bureau of Prisons. Anything further by the government? Ms. Poskeren, yes, Your Honor. I don't recall if the court assessed the special assessment for each count of conviction. The court, yes, I will have to impose a mandatory $100 special assessment on each of the indictments, on each count, and the sentence to be imposed shall be concurrent with each other in this case. Ms. Poskeren, and Your Honor, the government now moves to dismiss all open counts against the defendant. The Court, that application is granted. Anything further by the defense? Ms. Kirshner, no, Your Honor. The Court, all right, that is the sentence of the Court. All counsel, thank you, Your Honor.